And hello and welcome to another edition of DSU Inside Perspective. I'm Carlos Holmes, and this is the show where we talk with faculty, staff, students, and guests about current events or about things that are going on here at the great Delaware State University. Today we're going to look at Brown versus Board of Education. On May 17th, we'll be celebrating the 60th anniversary of that landmark decision. And today I have our Associate Provost and historian in his own right, Dr. Bradley Skelcher, with us today.
Pleasure to be here, Carlos.
Dr. Skelcher, the foundation, I guess, for Brown versus Board of Education, at least in Delaware, I guess, was kind of set in 1950, I suppose, with the case of Parker versus the University of Delaware. And that had some special relevance to Delaware State University. What was that case about?
Parker versus the University of Delaware in 1950 is one of the, in my view, one of the most significant court cases heard in the state of Delaware, but it also had national impact. What prompted the litigation against the University of Delaware was the threatened closure of what was Delaware State College by the state for a number of reasons. And so about 30 Delaware State College students thought at any moment the school may close, so they sued the University of Delaware for admission at the undergraduate level.
And at that time, they were not admitting black students.
Exactly. Delaware had a separate but equal educational system built into the state constitution dating back to 1897. So it was illegal to have integrated schools in the state from the primary all the way to the secondary education level. The students, nonetheless, weren't deterred by that, and Lewis Redding, the only African-American lawyer to be barred in the state of Delaware at the time, took on their cause, which fit Lewis Redding's own mission in life to fight Jim Crow segregation. His first record of that dates back to World War II, where he was fighting segregation in employment in the military service. Lewis took on the case and sued the University of Delaware. It went to Chancery Court. This is a special court in the state of Delaware. There's probably no other court system like it. It's specifically set up for business. However, it's a Chancery Court of Equity, and the court went through the equity because of equal protection under the law in the 14th Amendment. Lewis Redding argued before the Chancery Court. Now, the chancellor at the time, he was also a board trustees member for the University of Delaware, so he had to step down, and in his place was the
Colin Seitz.
Colin Shea Seitz, the vice chancellor of Chancery. He heard the case and ordered the immediate integration of the University of Delaware at the undergraduate level. What's significant about that is this was the first Southern university, public university, to desegregate at the undergraduate level. In the past, the NAACP Legal Defense Fund focused on graduate or professional studies, post-baccalaureate degree programs. This was the first one that went straight after the undergraduate, and they won, which sent a message to the NAACP that now it was time. If we could beat a Southern university at the undergraduate level, now's time to make the push for primary and secondary education integration.
So we move towards Brown versus Board of Education, and it's called Brown versus Board of Education after the case in Topeka, Kansas.
Yes.
But we had several other cases that were rolled into that case, a case from South Carolina, a case from Virginia, a case from the District of Columbia, and a case from Delaware, or two cases from Delaware.
Yes.
Beulah versus Gebhardt and Belton versus Gebhardt. What were those cases about?
Those cases focus on primary and secondary public education in Delaware. Ethel Louise Belton versus Gebhardt involved the the Claymont School District in northern Delaware. Belton, Ethel Louise Belton, was a high school student, and there were several others in that case against Gebhardt, who was the Board of Education, Superintendent of Instruction. There were several other students involved in the case, but Belton was the first. Typically, these are in alphabetical order. But looking at Belton, she was a high school student. She lived about a block and a half from the all-white Claymont High School, and so she could easily walk to school. And instead, because of segregation, she was bused along with their classmates to Howard High School in Wilmington. And now Shirley, or Ethel Belton, then had to walk 9 blocks uphill to the Carver School, vocational school. And on whether she knew it at the time, but later we discover, or she discovered, she had congenital heart disease, and she later died when she was 44 from this disease. So here's a kid being bused about 30 minutes or so to downtown Wilmington, and then forced to walk all this distance, suffering. The argument was, we have a school right here. We want to go to the school rather than being bused downtown. The Shirley Beulah case involved the primary schools in Hockessin, Delaware. Shirley Beulah's mother would drive her to school, to the Hockessin black school. And Hockessin's a bit hilly, and in the winter the roads were icy, so her mother was concerned about navigating these icy hills to take her daughter to school. So she requested that Shirley ride a bus to her school, which was denied by the Board of Education, State Board of Education, primarily because she was within the distance of where they didn't bus, and the only other bus was the white bus going to the white school. She wanted to have Shirley ride that white bus, deliver her at the black school while the other kids go to their other school. She went to who was fondly called at the time Lawyer Redding, Lewis Redding, to take the case on. Redding told her mother that, I will take your case on one condition. I am not going to secure you a ride on a Jim Crow bus to take you to a Jim Crow school. And Shirley's mother said, fine, we're going to fight for her admission into the all-white Hockessin school. So both of these cases came together, and these were heard before Chancery Court. And the Legal Defense Fund that took up this case in collaboration with Redding sent Jack Greenberg to represent the Legal Defense Fund and work with Lewis Redding. Jack Greenberg actually spoke here on campus about 11 years ago. Jack Greenberg also worked with Redding on the Parker case. So together they argued for the integration of both of the white schools.
And of course, that went on to contribute to the other attorneys' work in the case, and Brown versus Board of Education resulted in a ruling that segregation in public schools was unconstitutional.
Exactly, and you are correct, Carlos. Both of those cases were woven into the Brown case. Again, alphabetical orders, how the courts list these. But the one unusual part of the Delaware cases was it was the state of Delaware that appealed to the Supreme Court, not the litigants, because at all levels, the Chancery, beginning with the Chancery Court, heard by, at that time, he had risen to Chancellor sites, and that was upheld by the Delaware Supreme Court. The state took it upon itself to appeal to the Supreme Court. The other cases, the LDF appealed because they lost their cases at the state and District of Columbia level.
That raises an interesting question, and this is my last question for this segment. Why didn't the state appeal Parker versus the University of Delaware?
That's a good question. I really don't know. I do not know why that was not appealed, at least to the Delaware Supreme Court. That's
Okay.
a good question. I'll have to try to find that answer.
Well, maybe we'll figure that out next time we talk about Brown versus Board of Education here on DSU Inside Perspective. Dr. Skelcher, thank you so much
You're
for
welcome.
joining us today.
You're welcome.
And thank you for joining us for another edition of DSU Inside Perspective. Y'all have a good day now.